Yes.
But, under some comparing circumstances, I'm mentioning this matter, my lord, upon notice to the other side. This is, my lord, that matter UOPLA 2 of 2011 in connection with this property. Another suit was filed while a preliminary point is being argued. Now, my lord, in this testamentary suit, I am cross-examining the caveat, my lord. Lordship has fixed it on
Helena Wilson.
Helen Wilson. Lordship has fixed it on 5th. On 5th, my lord, I will not be in town. So, my lord, I am praying, my lord, if a date can be fixed after a week, either on 13th or 14th.
Come on 5th, I will adjourn it. Your junior will be there?
My junior will be there, my lord.
That's all.
I just thought, my lord, I should mention it because so that no inconvenience caused to the witness, my lord.
You take a note, I will adjourn it on that date.
But 13th or 15th preferably, or 14th. I have ascertained from my lord's office.
Yes, that's why I cannot pass it.
Whatever way. Very well, my lord. Either on 13th or...
Remind me.
My junior will be there. Great.
My lord, I would like to mention this matter for inclusion in the list.
There was a report to be filed by today, but the matter is not there in the list.
Supplementary list. It will be published in the supplementary list.
Lordship, may I file the report?
No, keep it with you. Record is not here.
Okay.
ওটাকে রেখে দাও or come tomorrow. Better come tomorrow. Come tomorrow. It will be in the list.
Lordship.
Lordship, may I be permitted to mention one matter? Lordship, upon mentioning, I am coming, Lordship.
Inclusion.
No, Lordship. Its determination got changed, Lordship, but this is the part hard matter, Lordship. Lordship, I am annexing the order. But hearing is not yet started, Lordship. If it is in the determination of Justice Victor Chaudhary, Lordship. I'm humbly paying for release.
What do you want? Inclusion in the list?
No, Lordship, release of this instant matter, Lordship, because the determination got changed, Lordship. It is in the determination of Lordship, Justice Vishwarup Chaudhary, Lordship, at courtroom number 9.
This is part hard matter.
Part hard matter, Lordship, but not hearing, not been start, Lordship.
Without other side, I should release it.
No, I have mentioned this matter.
This is not the way. Let the matter come, appear in the list, then I will decide.
Can you, Lordship, list this matter to be mentioned?
No. A date is fixed. When it is fixed?
Lordship, last date was Lordship 22nd of April 2025. After that, no.
Next week of 7th May. It is fixed on 7th May. This is not the way.
Or just I listed matters, item number 1 and 2. Please,
I was addressing your lordship on the respondent's application for by which assailing the dismissal of their counterclaim. Now, my lord, I told your lordship, my lord, that their counterclaim was in the nature of damages. Counterclaim was...
Take care of your glass.
Counterclaim was in the nature of damages. The counterclaim was dismissed by the learned arbitrator on coming to a finding, by the learned tribunal, I'm sorry, my lord, on coming to a finding that the claimant's claim for damages merits dismissal because the claimant has not given the respondent an opportunity to rectify its breach, which is the 30, 60, 90, 60, 30-day notice provision in the contract.
Neither of you has done that.
Neither of us have done that. So the learned tribunal was of the view. I adduced some evidence to show that I had done that. That was not accepted by the learned tribunal because it said you have not specifically pleaded in your pleadings that this is the way you have complied with that 90, 60, 30 requirement. So evidence beyond pleadings, we will not consider. So on that ground, they dismissed that. The second ground which I had taken, my lord, that the respondent has abandoned the contract and therefore I'm not required to give any notice because there's a separate clause in the contract which provides for that. That did not find, my lord, that the learned tribunal did not accept. So on these two grounds, my claim was rejected. Now, the first ground on which my claim was rejected, that I have not given the 90, 60, 30-day notice and therefore I'm not entitled to claim damages. That same reasoning the learned tribunal followed for dismissal of the counterclaim. The learned tribunal said that we have already held that you cannot make a claim in damages without giving this notice. Now, the respondent's claim is also sounds in damages, the counterclaim, and therefore, for the self-same reasons, the counterclaim also stands dismissed. So, may I show your lordship the paragraphs in the award apropos this? Because your lordship has seen on the last occasion I addressed your lordship that the claim was for there was an injunction which was in aid of damages. That's section 40 of the Specific Relief Act. Your lordship has made a note. So I don't think I need to trouble your lordship too much on this aspect of the matter. Your lordship will kindly see the award, because the primary contention of the petitioner, as I've been able to understand, my lord, is that the award does not give any reasons as to why the counterclaim has been dismissed. That seems to be their primary contention, and that their necessary evidence, etc., has not been considered. The evidence, question of consideration of evidence did not arise because it was not their case that they had complied with this 90-60-30, like mine. I had at least made a case in the arguments that, see, I may not have specifically pleaded this, but please see the evidence which would show that I've complied with this, which was disregarded by the learned tribunal, saying that evidence without pleadings cannot be considered. Full stop. That's the end of the matter. In their case, they did not even make such an attempt. Theirs was simplicity, claimant has wrongfully terminated, or that there is no termination, contract is still subsisting. That was their case in the arbitration. Their pleadings, and I want to show your lordship their written notes of arguments which they filed in the arbitration, which is very important, because that would show what was being argued in the arbitration. Because I find, with the greatest of respect, some divergence between the arguments made before the learned tribunal and the arguments advanced before your lordship. The case before your lordship has to be the case which was before the tribunal, and that too within, my lord, the limited contours of a section 34 application. Section 34 jurisdiction, my lord, is very limited. Your lordships have repeatedly held that we are not a court of appeal. We are not a court of appeal. We are only to see whether the grounds,
Certain grounds.
only limited grounds. That too, what is specifically mentioned in 34 cannot add to that, we cannot add, and we cannot substitute our view in place of the view of the learned arbitrator. So unless the award can be said to be perverse, that is the high test which your lordships have said, unless the award is said to be perverse or against the public policy of India, we will not interfere. Because parties have chosen a forum for alternate dispute resolution. The court of law was open to you. You could have easily come to court and agitated your grievance. You choose not to do that. You choose to go to a domestic forum, an arbitral forum. You decide who your arbitrators are going to be. Because it is entirely consensual, my lord. Your lordships don't impose arbitration on us. Your lordships leave it to the parties that you can have an alternate dispute resolution mechanism, which is by way of arbitration. You can also decide who your arbitrators will be. So full freedom of choice is given to the parties. Your lordships therefore say that once you have exercised your choice of having your dispute resolved by Mr. X, Y, or Z, unless the decision of Mr. X, Y, or Z is so perverse that it shocks the judicial conscience of the court, we will not interfere. Because that is the bargain you have made. You choose to put your fate in the hands of a private tribunal. Now you have to abide by their decision. And that is why all these principles, my lord, of competence, that the tribunal will rule on its own jurisdiction, we will not decide. All this stems from that, because it is a consensual contract between the parties, and your lordship say you must abide by that contract. You cannot upset the contract on your whims and fancies. So, my lord, the principal ground of challenge that the learned tribunal has not given reasons, the greatest of respect, may not be correct. That would be doing injustice to the members of the tribunal to say that they've not given reasons. So may I just show your lordship the award for that matter? And in the award itself, their entire pleadings, their written notes of argument, everything has been considered. Your lordship will kindly take the award, because the award will speak for itself.
Where is the award?
The award is at...
Yes, I've got it.
Your lordship has a separate award, my lord. Kindly bear with me, my lord. I'll trouble your lordship with the internal pages of the award, which is at the bottom of the award, bottom of each page, my lord.
Yes.
It has an internal page. Now, if your lordship kindly comes to internal page 38 of the award.
Yes.
At paragraph 7 onwards, my lord, the learned tribunal considers the statement of defense and counterclaim filed by the respondent. Kindly see the reliefs which are sought. An award for a sum of rupees 53 crores odd more fully stated in paragraph 1, LII, small ii. This, your lordship will find at internal page 53, this pleading, LII. If your lordship may kindly turn to internal page 53, is the claim for damages.
53 of
53 of the award, please, my lord, the internal page at the bottom, because there are so many compilations, my lord. Kindly see LII. The respondent is thus entitled to. Your lordship has that?
53 of the award.
Yes, please, my lord. The number at the bottom of the page, my lord. Kindly,
Yes, that's
yes. 53 of the award, your lordship will see the third paragraph.
yes.
Yes, your lordship sees that. The respondent is thus entitled to a claim for a sum of rupees 53 crores odd on account of aforesaid grounds, more fully stated herein below. DM entitlement, that is, my lord, the development manager entitlement, as per clause 8.1 of the development management agreement. Now, my lord, the pleading apropos this amount, your lordship sees 29 crores. The pleading apropos this, if your lordship kindly turns back one page, my lord, kindly comes to page 52, the last subparagraph at the bottom of the page.
In terms of the work
Yes,
carried out.
in terms of the work carried out by the respondent in respect of the said project, the respondent is entitled to 10% of the realization or gross sales revenue of the entire project, being the development manager's entitlement and incentive fees as more fully stated in clause 8.1, read with schedule 3 of the DMA. Consequently, the respondent is entitled to an amount of rupees 29 crores as its entitlement in terms of the said clause, particulars whereof are given in a schedule marked as Annexure D. My lord, may kindly make a note here. This schedule Annexure D is at page 703 of volume 3. I don't want to trouble your lordship with that, but kindly make a note, my lord. In their convenience compilation, this schedule is found to be found at page 703 of volume 3. So therefore, my lord, this subparagraph would show that their claim is for damages. Had you not terminated, I would have been entitled to rupees 29 crores if the project had been completed. Premature termination of the contract, I have suffered loss and damages of 29 crores. So this is their claim. And there are the other subheads on account of cost, repayment, etc. I'm not
Cost damages and so and so.
Yes, cost damages and so on. So reimbursement claims that we are not my lord, troubled with presently. Then your lordship now kindly comes back to page 38, please, my lord, where the paragraph 7 I showed your lordship, my lord. Then kindly see prayer B there. An award for assessment of damages and loss suffered by the respondent due to the arbitrary actions of the claimant. This, my lord, is assessment of loss is like inquiry into loss and damages. They've just rephrased the term award for assessment of damages. So inquiry into loss and damages due to the arbitrary action of the claimant. Prayer C, award of perpetual injunction restraining the claimants and each of them from preventing the respondent from rendering services as a development manager. Then prayer D, award of perpetual injunction restraining the claimants and each of them from doing any of the acts covered under the development management services. An award for perpetual injunction restraining the claimants and each of them from obtaining any of the services similar to that provided by the respondent under the DMA in any manner whatsoever. These three, my lord, prayers, C, D, and E are in terms of section 40 of the Specific Relief Act. Injunction in addition to damages. Injunctions, my lord, in addition to damages. So primary relief sought is damages. And the secondary relief or the injunctive relief is injunction in addition to damages, which is also, my lord, in the written notes which they filed before your lordship, my lord. So prayers C and D, CD, in fact, your lordship sees, although the learned tribunal has not made a note of it, but your lordship will certainly appreciate. Prayer A is for the entire amount which he would have recovered if the project would have been carried out. He says, if the project carried out, I would have got so much money. Now, prayer C, D, and E, by C, D, and E, he wants to restrain me from doing my project, and at the same time, he wants his full money of damages. So he wants, in other words, he wants to have his cake and eat it too. You will not do anything which I was supposed to do. He doesn't say, I will do it myself. He doesn't say specific relief. He doesn't say that my decree for specific performance, he doesn't say. He doesn't say that the agreement should be specifically worked out. If he says that, then he cannot get damages, because then it has to be in the alternative in terms of section 21. You can either have specific performance or you can have damages under section 21 of the Specific Relief Act, but you cannot have both. So A, he says, I want my full damages, as if the whole contract had been worked out. And then C, D, E says, you don't do the contract. So that is why perhaps the dichotomy in the averments here. And that is, now your lordship kindly sees where this case is on my termination being wrongful, because the same would apply to him if he is seeking damages. Kindly come to paragraph. The agreement has been considered. Kindly come to subparagraph. Sorry. So the entire, kindly come to, yes, paragraph page 52, please, madam.
Page
50. 52 is where your lordship has seen. 52. Now kindly turn to 53 again. Kindly see L.
53.
Yes. In bottom page 53.
L
Yes.
in the alternative.
Yes. In the alternative, respondent is entitled to claims on account of loss and damages suffered by the arbitrary and illegal actions of the claimants. This is at prayer B. In the course of the DMA, the claimants have all times acted in an unprofessional manner. Now, Malad, kindly see what has been highlighted by the tribunal. The termination by the claimant number 1 is also in violation of the provisions of the DMA. So, the specific case is that the termination is in violation of the agreement between the parties. The agreement between the parties provides for this notice, which they specify in page 57 now, Malad. Kindly come to page 57. Paragraph 6, which is set out. Kindly see the highlighted portion, Malad, where the tribunal has supplied emphasis. Your lordship sees furthermore. Furthermore, the claimants were required to issue notice for default for failure to achieve any critical milestone, which were never issued to the respondent in terms of clause 18.1.1 sub 3 of DMA. Therefore, the claimants have acted in violation of the terms of the DMA by raising such allegations before this honorable tribunal for the first time without issuing any notice of default. This is their specific case.
Your claim was?
My claim was for damages, that they have abandoned the contract because of their breach, basically delay and non-performance of their obligations. I am entitled to damages. That
Your
was my-
plea was it was repudiated.
Yes, it was repudiated by him.
And their claim was?
Their claim was that I have wrongfully terminated.
So finally,
Finally,
Tribunal
the tribunal held. So, my lord, what the tribunal holds finally, my lord, kindly one more paragraph, please, my lord, at page 64. Kindly come to page 64, please, my lord, paragraph 14, where the tribunal has supplied the emphasis. It is denied that, your lordship has that. It is denied that the respondent renunciated the DMA as alleged or at all, because this was my case of renunciation repudiation. As the respondent did not renounce the DMA, the question of the claimants accepting such...
second volume to the.
I'm sorry.
Just a minute. Just to refresh the memories.
Yes, of course. If your lordship has any query, my lord, I can assist, my lord, take out the papers. Help your lordship with the papers. Second volume.
Last page is
Your lordship is seeing the award, is it, madam?
award itself. The
Award
last
itself.
pages of the award. Second volume must be in the second volume.
Yes, yes. Where is the last page of the award, my lord? I am carrying.
The conclusion. I want to see the conclusion.
Your lordship will see the conclusion. It starts at page 169 or internal page 169, which is volume 1 itself. It is, my lord.
Volume 1.
Kota onek alada alada. Volume 1 of what? Volume 1 of the convenience. Your lordship has made notes in the convenience. Yes, yes. Your lordship has made notes.
Rakho to rakho. You said page?
I was troubling your lordship with page 64. My lord, lordship wants to see the conclusion first, is it?
Yes.
Kindly see the conclusion first. It is at page. Kindly see page 169.
169.
Yes, page 160. Kindly see paragraph 42. This,
Claim is rejected.
yes, my lord, may I read
Dismissed as
further?
for want of valid notice.
Yes, may I read further, my lord? May I kindly place it, my lord? Kindly see 42. Since the tribunal is of the view that the claim application is not maintainable for want of any valid notice to remedy the breaches, in spite of those being remediable and curable in nature or otherwise, the offending party can substantially mitigate the effects of, if cure is not possible, if any, as provided in the DMA. Kindly see the next few words, my lord, very important. For the self same reason. Lordship sees paragraph 42. For the self same reason. This is the, my lord, reasoning of the learned tribunal. And perhaps your lordship's attention was not drawn to this paragraph, my lord. For the self same reason, in the absence of the 3 notices issued by the respondent to remedy the breach of the claimant by withdrawing the order of wrongful termination, it has not decided to enter into those
It
factual...
has decided not to enter.
Yeah, I'm sorry. It has decided not to enter into the factual allegations. So, my lord, admittedly, I'll show your lordship from the pleadings and the written notes of argument which they file. They don't say that we have given this notice to the claimant to withdraw his termination. And this is then comes to, my lord, this is the start of the reasoning. Kindly come to paragraph 46 now at page 171 bottom.
On the self same reason.
Yes, it is the self same reason. I at least tried to make out a case that, please see, my lords, the evidence is there that I have complied with this. The learned tribunal said, nothing doing. You have not pleaded this. We will not look into this. It is for the self same reason of not complying with this 90, 60, 30-day notice. So the reasoning is very much there.
Now, which clause of the agreement you are referring to?
Yes, the clause of the agreement. So your lordship has seen this is the reason, 42, 46 and 47. In view of the specific finding recorded by this tribunal, while accepting the respondent's contention that the claimants illegally terminated the DMA without giving opportunity to remedy the breaches, if at all by violating a fundamental breach, so and so, respondent is also not enabled to maintain any counterclaim without giving any opportunity. And the identical clauses. Now, your lordship kindly sees the identical clauses. Kindly come to the terms of the agreement which are set out in this award itself. Kindly see paragraph. I'll give your lordship the page number. Where the award terms are set out. Yes. Kindly come to internal page 98, paragraph 12 of the award. Internal page 98 of the award, please, my lord. Page 100 of the convenience compilation and 98 of the award.
Therefore, the only question for determination.
No, you're giving some wrong number.
Paragraph 11.
Yes, I'm so grateful. Yes, my lord. Paragraph. Therefore, the only question that falls for determination in this proceeding is as to which of the parties have committed the breach of the DMA dated so and so. If
The conclusion is both of them committed breach.
Both of them. I committed breach by not giving him, according to the learned tribunal, I'm not on my 34. According to the learned tribunal, I committed breach by not giving him an opportunity to rectify his breach. The remedy, 90, 60, 30. I committed that breach and I wrongfully terminated. Now, that is as far as my claim goes. He committed breach, that he could not have come straight for damages without telling me that your termination is wrong. If I have done a breach by terminating wrongfully, that is breach on my part. He ought to have given me notice of the same 90, 60, 30 that look here, you have wrongfully terminated.
Basically, according to the tribunal, both of you are in the same boat.
Yes.
Same type of breach.
Yes. Same breach, same clause. Clause 18. Only thing is 18 is 18.1 for me. I have
None of you have given any notice for rectification.
Yes.
That is the sole.
So the claim is premature.
Sole ground.
Rejected. Yes.
Now, what are your points?
Yes. Now your lordship. So your lordship sees the clause. Your lordship wanted to see the clause, please, my lord. Kindly see 18.1.1, which is at page 99. Kindly see 18.1.2, since we are on the counterclaim.
18 point?
Next page, my lord. 18.1.2 at the bottom of the page. Kindly turn over.
This is quoted.
Yes, it is quoted, my lord. The tribunal has applied its mind, my lord. Kindly see page 99 bottom. The development manager
May at its option.
yes, may at its option terminate this agreement in the following events. Now kindly come to 5. A subclause 5 at the next page, my lord. If the developer, I'm the developer, he's the development manager. If the developer fails to materially comply with or cause the material compliance,
It should be fails.
yes, if with any of its obligations under this agreement, and my lord kindly sees fails to cure. So my breach, I fail to cure my breach, or otherwise remedy or substantially
A
mitigate.
notice to cure.
Yes, this is the notice to cure. Identical.
You did not issue notice to cure.
He did not issue notice to cure.
You did not issue
I
also.
also did not issue notice to cure. And he also, when I made the defect, I terminated. The tribunal says you terminated wrongfully without giving notice to cure. So that is my breach. So if I committed a breach, then he had to require me to repair that breach, to cure the breach by giving me notice. That look, you have wrongfully terminated my agreement. Because that is there in 18 point. This notice to cure as far as me is in the previous page, my lord, subclause 3, 18.1.13. So I say that he is in breach. My development manager is in breach. Then I have to give him notice to cure, 90, 60, 30. The tribunal says you did not give him the notice to cure in terms of 90, 60, 30, and you straight away terminated. Therefore, you are in breach. Your termination is wrongful. You will not get any damages. So my claim goes. Now, when it comes to his turn, the tribunal says, look here, you said that he has wrongfully terminated. I agreed with you. Because it is specific case, your lordship has seen the pleadings in the defense that I have wrongfully terminated without giving him notice to cure. So then the tribunal says that if he has wrongfully terminated without giving you notice to cure, how do you then accept the termination and claim damages without giving him notice to cure his wrongful termination? That is logical, my lord. What applies to him, the same clause applies to him also. So that is the reasoning of the learned
Now
tribunal.
you come to the agreement.
Please, my lord. Now, these are the relevant clauses which are
Yes,
set.
I understood.
Yes. So the agreement then says, as far as he is concerned, is that also he has to give me notice to cure. So I wrongfully
So
terminated.
understandably, both of you are in the same boat.
Yes.
According to the tribunal, both of you committed the same wrong.
Committed
Now,
the same.
what is your defense? What is your plea?
My plea, as far as their section 34 is concerned, my lord, it has been rightfully terminated. Rightfully rejected. And this 34 should be dismissed because he has not even pleaded an alternate case of renunciation or repudiation which I have. My lord, if I may just show you lordship, one paragraph of the award, why my case was not accepted by the learned tribunal now. Kindly come to paragraph. Paragraph 40 at internal page 147. I'm slightly digressing, my lord, on why my claim should not have been dismissed. Kindly come to paragraph 40 at page 147 bottom. However, your lordship has that. However, no service of notice to remedy the above alleged breaches having been pleaded in the statement of claim. The claimants cannot agitate those allegations in this proceeding for want of any notices of remedying these alleged breaches. So the learned tribunal is of the view that very good. He is in breach. Your development manager is very naughty. He has committed all these breaches. But where have you pleaded that you gave him the notice to cure? And therefore, we will not consider any of this. So that is why my statement of claim was rejected. Now, I at least made out that case in arguments and by the evidence which was on record. All this evidence of mine is noticed by the tribunal that you have put all this evidence, but there is no pleading. He did not adduce any evidence at all that he has given me any notice. So the tribunal says that it is not even your case that you complied with 18.35. Therefore, you cannot be awarded damages. His termination is wrongful. I set it aside. So he cannot claim damages. Your claim for damages is equally bad. Suffers from the same defect.
Now you understand this. What you have, so this is the discussion or this is argument on why the tribunal has committed wrong.
Yes.
What are your points?
Now, my points are, if your lordship kindly sees their written notes of argument, just to support the finding of the tribunal that their case also deserves to be dismissed. In the written notes of argument, my lord, your lordship will not find any mention of compliance with this clause. In the written notes of argument, which is in compilation, no, Please. Page 452, convenience compilation, volume 2 देवें एक जज शायद पे please. ठीक है. Kindly have convenience compilation.
Page
452, please, my lord.
starts from 452.
Yes, this is their final written notes of argument which they file. Kindly see the index once, please, my lord. Kindly see serial G of the index. Admittedly, the procedure for termination of the DMA under clause 18 was not followed by the claimants. This is their case. Then your lordship kindly sees, I have failed to make out any claim. Then my lord kindly see J. The respondent has made out its claim. The respondent was not required to terminate the DMA entitlement fee, loss and damages, etc. So my lord, he says, and now your lordship kindly sees the written notes also. Apropos this is the way he structured his argument before the learned tribunal. Kindly come to page where he says, where he deals with this notice not being given, and therefore my claim should fail. Kindly see page 485, please, my lord. Admittedly, the procedure for termination of the DMA under clause 18 was not followed by the claimants. And his case has been accepted. But where he stops short is he stops short at 18.1.1. Clause 18, my lord, of the agreement your lordship has seen applies to both parties. How it is to be terminated by both, it is there. So, my lord, this is a specific case which the tribunal found in his favor. Then kindly see J, where he makes out the case in support of his counterclaim at page 495.
Yes.
The respondent, can you see serial
Yes.
J?
Filed a counterclaim.
Has filed the counterclaim.
Inter alia
seeking injunctive reliefs in the nature of specific performance, as well as damages and compensation for wrongful termination of the DMA. So, injunctive relief in nature of specific performance is section 40, my lord, of the Specific Relief Act. They submitted that section 53 of the Contract Act inter alia provides that where a promisee prevents a promisor for performing his part of the contract, then the contract becomes voidable at the option of the party so prevented, and is entitled to compensation for the promisee for loss caused due to such non-performance. Furthermore, section 54 provides that where reciprocal promises are to be performed in a manner where one party cannot claim performance from another party unless it has performed its part, and such party fails to perform, it cannot complain for and shall be liable for compensation to the other party for loss caused. All these are for compensation and damages, no dispute. In the present case, the obligation to obtain sanction plan, this is on the merits, my lord, whose breach it is. I am not troubling your lordship with the breach. Then kindly see 87. Furthermore, it is submitted that by wrongfully terminating the DMA, the claimants have prevented the respondent from performing its obligation under the DMA. This is very important. Thus, upon wrongful termination, the DMA becomes a voidable contract under section 53 of the Contract Act. Additionally, the respondent is further entitled to claim compensation for the loss suffered by it. The minute he says this, my lord, that the DMA was wrongfully terminated and I have prevented him from performing its obligations under a DMA, he was required to give me a cure notice. So, this is, my lord, his specific case before the tribunal.
So your point is, if it is wrongfully terminated, there should be a rectification notice.
There should be a rectification notice.
That is not done.
That is not
So
done.
they have not complied with it.
They have also not complied. This is a specific case, wrongful termination. If it is wrongful termination in breach of clause 18.1, then you have to give a cure notice that this termination is wrongful. You withdraw your termination, let me do the contract. Now kindly see, if I don't withdraw my termination, I don't withdraw my termination. 90, 60, 30, I do not do. Then he can claim damages because then he treats the contract as terminated. He puts an end to the contract and he comes and seeks damages. Otherwise,
So according to you, counterclaim is rightly rejected.
counterclaim is rightly rejected.
And what about your claim?
Now, my lord, on my claim, may I just deal with the judgments which Mr. Mukherjee has cited, my lord, in support of his section 34 once. As
You
to,
do one thing, come with the notes of argument.
please, I will do that. I will put my distinguishing features in the notes of.
Yes.
Kindly give your lordship's board is very
2
heavy, my
weeks.
Yes, please, my lord. That will take us into the vacation then, my lord, after the vacation. Last week, my lord, your lordship will not take up a hearing matter then.
Makes no sense in fixing a date.
Before the vacation, my lord, hearing matters, your lordships are troubled by the interlocutor.
Heard Mr. Thakkar in part adjourned to 12 June.
Please. Well, grateful, my lord, deeply obliged. Now, my lord, it will not take long because your lordship is fully in season of the matter. Your lordship, we are opening on the 9th, my lord. Can it be 1 week after the 9th? So, my lord,
ওটাকে চেঞ্জ করে দাও 17 জুন
please. Grateful.
Mr. Ghosh, one word. If you're not happy with this court, mention that on the day fixed. Do not send your junior to mention please release without giving notice to the other side. That is done on behalf of Sonex TV. Just this morning,
I'm not aware of this.
someone came, a junior, of course, she was a junior, came and asked me to release the matter. And how this can be done in absence of any other party?
And I'm not aware of this.
Take care of that.
Grateful, my lord. Thank you.
Item number 5.
I'm appearing for the defendant, substituted defendant. On the last occasion, lordship was pleased to allow the substitution application. Now,
Who is the plaintiff?
Sorry, my lord, I was praying for a week's accommodation. My lord, the substitution and amendment had to be carried out. My client could not come. He's sick. I was praying for 7 more days to carry out the amendment and the substitution.
On prayer of the learned counsel for the plaintiff. Then you have to file WS.
yes, my lord.
But in my humble submission,
Filed an application, my
this was a substitution application. He was not added as a party. He was substituted in the place and seat of the original defendant. So he has.
Let this be
yes.
done, then we will take care of it.
very well.
On prayer of the learned counsel for the plaintiff, the suit is adjourned to 12 June.
And let them serve the copy of the
Let these things be done first.
Item number 6 to 9.
My lord, I am for the plaintiffs, my lord. All
Please
the
your other side.
Your lordship on the last day has directed me to give a status of all the matters. I am giving it one by one, my lord. Lord, so far as the first item, CS 92 of 2017 is concerned, my lord. Here, my lord, the examination of the plaintiff's witness is complete, and the examination in chief of the defendant's
Just a minute.
witness is
CS 92, that is
92.
item number 6.
yes. In this matter, my lord, the examination of plaintiff's witness is
So
complete.
we have nothing to do in first one.
Only, my lord, if your lordship kindly extends the time because your
Extended it till 19.5.
yes,
make a
19.5.
small submission.
On the last day, it was fixed, my lord.
Just a minute, I will hear you.
Last day, it was fixed, my lord, but the defendant's witness was ill, so therefore he could not come.
So I am fixing it. Time is extended till 19.5. So after 19.5, a day will be fixed.
Extension would be required. my lord.
Yes.
My lord, my submission is these 4 suits are interconnected. In 4 suits, all the defendants are same. There is a check involved. The series of the checks are same. So now, my lord, in 92, my witness are being examined by me, defendant's witness.
Are these
And-
commercial disputes?
My
Lord,
lord,
no,
this
lord,
point-
this point your lordship has kept to by an earlier order.
I have
My lord,
to
the
make
party
submission.
that the defendant is same, but the parties are different and the suits are all completely at different stages, my lord.
Yes,
Therefore,
my lord,
this
may-
prayer,
may
my lord,
I
my lord,
make submission, my lord. My first prayer is that CS number 93, this has not been started. My learned friend is appearing for the plaintiff.
92, with your lordship's leave, my lord, there are 4 suits. My lord, the defendant is the same in all 4 suits. I am the defendant in all 4 suits.
Let me know the status one by one.
Yes.
I have got it
92.
of
Lordship.
92.
In
What about other?
92, my lord, I am in
93, my lord. The witness has not yet
Not
been
started.
commenced. Only issues have been framed.
in 95 and 96 now, my lord, examination in chief of the plaintiff's witnesses ongoing.
So except this 93,
Yes.
in all other cases, witness action is going on.
Lordship.
On
But
commission.
in first one, the plaintiff's witness is complete. Defendant
that might be,
started.
witness
And the
action is
other
going
one,
on.
another 2, my lord. Plaintiff's witness is in chief.
My lord, that we have a prayer
On
with regard to
commission.
that.
Yes, my lord.
We have a prayer in
all-
regard to
All
that.
the 3 matters are on commission. So far as 93, no commission is there, my lord.
My lord,
The commission is there, but it has not started, my lord. Right, 93.
my lord, we have one prayer to make. Lordship will see. It's my humble submission, my lord, that these 4 matters are interrelated. I am the defendant in all 4. The plaintiffs are notionally different in the 4, but they are really alter egos of one another. That is my humble submission. Now, my lord, the CS 92, as your lordship has heard, my lord, it is in witness action. The plaintiff's witness examination in chief, cross-examination completed. Defendant's examination in chief is ongoing. That is at the verge of completion, my lord. Certain additional documents we wanted to disclose. We obtained the leave of the court. In one sitting, it will be complete. Thereafter, the defendant's witness will be cross-examined. And in 95, 96, as your lordship has heard, my lord, the examination in chief is ongoing. Now, the difficulty is, if in 92 is commenced, my lord, the witness action is commenced from the stage of cross-examination of the defendant's witness, whatever lacunas are, my lord, elicited in the plaintiff's case from this process of cross-examination
Will be cured.
they will fill up in 95 or 96 where the examination in chief is going. This is
So-
my apprehension. So I was humbly praying, my lord, that the examination in chief or cross-examination of the defendant's witness in 92 await, my lord, the completion of the chief in 95, 96. This is my humble prayer.
Well,
And 93 can start so that, my lord, we are on the same
Let this
stage.
commissioner is appointed, let this be proceeded with.
Lord,
You ask on these
let-
questions and
Let me
cross-examine.
clarify one thing. My lord, the prayer which has been made, completely made on some disputed questions of fact. They have said that petitioner plaintiffs are alter ego of each other. That is a factual assertion which I strongly deny. Because plaintiffs
I
are
have no
different.
petition to decide
My
on
lord,
the issue.
basically, my lord, defendant has
I-
So for the
taken a
time, when the witnesses are examined partly,
Yes, ma'am.
except one,
Yes.
then let this go on.
yes,
At that time,
all
this
are
was
in
not
different
decided.
I will take the appropriate steps.
If a
and come back.
person, my lord,
Yes,
if a
let
person
me
takes
pass
a
order.
if a person takes a stand, stereotype stand against the world, that whenever he has
At the
issued a
time
check
of
that has been
examination of
that has
witness,
been
when
stolen from their
witness
custody.
action began, this question was not decided, not agitated. So let it go on.
Yes.
But then
If-
today I confine my prayer only to commencement of the witness action in 93, nothing more.
Witness action in 93 of 2017, commissioner is appointed.
Yes, my lord.
I'm told.
93 the commissioner appointed. 93 the commissioner.
93 of 2017, witness action in 93 of 2017 is yet to commence. The learned advocate commissioner is directed to commence examination of witnesses as early as possible. All the suits will appear in the list for further order on 21st May. I will pass further orders.
Yes, deeply appreciated.
Good.
And all the matters will continue.
Yes,
Kindly make that.
because witness action will
Yes,
not be complete on that date.
yes.
I will extend time.
It cannot be stalled like this. Deeply appreciated.
Just a minute, just a minute.
Yes, sir.
The learned commissioner shall be present on the present day, on the returnable day.
There are 2 other commissioners. One is Mr. Mitra, another.
Learned
is Mr.
commissioners. A copy of this order may be communicated to the learned commissioners.
Deeply appreciated.
By the register. Item number 10.
Yes, Lord, I'm appearing for the defendant, Lord.
What is J3?
Yes, Lord, this matter, Lord, what happened, Lord? This honorable court was supposed to direct to file the amended plea. But the amended plea was filed, Lord, but the still certain amendment has not been carried out, which you have pointed out in my applications, Lord.
In J3?
Yes.
There are some typographical defendant and defendants. Only yes, my lord, that has been overlooked, my lord. That may be correct.
Yes, Lord.
We
And I
try
have
to
rejected
Rejected,
the
my lord.
application.
Copy was
Please.
given them, they have rejected.
J3 of 25 is filed. by the plaintiff. Plaintiff,
No,
No.
defendant.
defendant, praying for, no. This is leave to file written statement.
Yes.
This is separate application.
No, my lord. Yes, my lord. After the
Further correction.
At which 10, my lord.
আচ্ছা ওখানে লেখো filed by the defendant praying leave to file written statement in the suit after correction, carrying out the correction and amendments in the plaint. Full stop. Para 10 of the application set out instances of incorrect amendments. This is not in the plaint itself.
Yes. In the plaint, amended plaint, my lord.
Amended plan.
Not in the proposed plaint.
No, not in a proposed plaint.
You will know. Set out instances where erroneous, incomplete, incorrect amendments are found in the plaint. Plaint দেখি একটু This should be, for example, come to para 10, page 6.
Yes.
It should be defendants.
Defendant.
Because all other defendants has been
Defendant. Name of the defendant number 2 and 3 was deleted.
This should not an application for deletions was filed, my lord, for deletion the name of the defendant number 226, my lord. That was
For
allowed, my lord.
example, it mentioned paragraph 8, instances mentioned in defendants. Here it is defendant number 1.
Defendant, only defendant.
Only one defendant.
Sole defendant.
Sole defendant. It is mentioned as defendant number 1. So what is the problem with paragraph 8?
That was described as defendants, my lord.
Defendant is to be deleted, my lord.
Instead of defendants, it will be
In the
defendant.
proposed plaint, it is there or in the original plaint?
Amended plaint.
Amended plan which was served upon him on
Amended
copy, my
plaint
lord.
served on us.
Amended plan has not been filed.
Where is the amended plaint? But these amendments are not carried out in the plaint
not
itself.
amended plan not filed. Only copy was served
Copies
upon
are
him.
served upon us.
This is not yet to be carried out.
Yes.
So the amended plaint, proposed amendment is to be rectified.
Yes.
Where is the amendment application?
Yes.
Where is the amendment application? Let the amendment, it was disposed of possibly.
Yes, what happened, my lord? In this should not an application for deletions of the name of the defendant number 226 was filed, my lord, because as against there was no cause of actions, my lord. So, my lord, that was allowed, my lord, and the department was directed to carry out the amendment. Then, my lord, the amendment was carried out, my lord. Still, there
But the
was
plaintiff
certain,
has no amendment, no corrections are there.
yes, my lord, that
See-
was not fine.
See paragraph 8. Nothing is amended, nothing is corrected. Here paragraph 8 is mentioned in this application.
Yes, my lord, they have served a copy, my lord.
Only copy was served.
Do one thing,
Amended
do one
plan
thing.
not-
Please sit with this application, proposed corrections, and this suit, this plaint, original plaint. You will find number of corrections and no corrections are there. So proposed amendment are to be changed.
Yes.
So that's why that application is a disposed of application. I have to call for that application.
Yes.
What was that application number?
Because they served, my lord, the amended plaint, my lord, upon us. my
That
lord.
might be served upon you, but here there is nothing. No corrections are there.
That is, my lord, that has to be done by them, my lord.
Let the application come, amendment application come,
Yes.
containing proposed plan. Get it out. What is the number?
G number to
J number.
That is
I invite your lordship's attention, my lord.
My lord, kindly see page 2, my lord, of the plaint.
Page 2
Page 2, my lord,
of this application.
of this plaint, my lord. The department has corrected, my lord, deleting the defendant.
Yes, J2, IAJ number 2. Name of 2 and 3 are deleted.
Yes.
Defendant number 1 is mentioned, but you mentioned certain corrections to be done.
Yes, sir.
These errors are not in the
In
plaint
the
itself.
body of the plaint, my lord, some
Nothing is
correction
there. Please check it. Please check it. You says paragraph 8 instances of mention of defendants.
Only.
Where it is? It is all through defendant number 1.
This has been done by the department, my lord.
No correction is there.
Yes, my
Try to understand the matter.
That is, my lord, sir, amended plaint need to be filed, my lord. That
Lord,
is,
unless plaintiff has to
I have
amend the
served upon
plaint, my
what-
lord,
Let the application come.
yes.
Let the application come. Let me understand. But he's saying I can understand what he's saying. IAGA 1 of 2 of 2023 be placed before this court for effective hearing of GA3 of 2025. Let the matter appear in the list on 19th May. And then June after vacation. 12th June.
My application for amendment of the plaint had appeared on the last occasion.
Please, your other side.
No, Mr. Dheeraj Trivedi appeared, my lord. My lord, the affidavit of service, my lord, had already been filed on the last occasion, my lord. On the last day also, my lord, when the matter had come up, that day also they did not appear, my lord.
Order sheet to देखिए. This is a prayer for amendment.
Yes, my lord.
Proposed amendments are there.
Yes, my lord. If the second volume, my lord, has the proposed amendment. Second volume, the plaint starts at page 100.
Why so many volumes for an amendment application?
My lord.
Why so many volumes for the ground of amendment?
My lord, ground of amendment here, what has happened, my lord? We had challenged a particular sale. We didn't have the documents of
in spite of reasonable diligence, could not in spite discovered the alleged 4 deeds of conveyances.
Yes, my lord. This was discovered only when, my lord, the defendant here, they preferred in an appeal, my lord, from Order 7 Rule 11, in a supplementary affidavit filed in February 2025, they annexed copies of the sale deeds. Only then I could challenge them, my lord, and that's why I filed it.
You want to add paragraph 40A?
40.
Anything more? 40A to
40A to 40G at page 136. Challenging these 4 deeds. And, my lord, a prayer has also been added. Prayer AA and prayer AB.
Today is fixed for hearing J9 of 25. An application for amendment of the plaint. Affidavit of service is filed. None appears for the defendant. On the previous occasion also none appeared for the defendant. Let the matter appear in the list on 8th May for hearing. In case defendant fails to appear, the matter will be heard without his presence.
Obliged, my lord.
Item number 12.
I'm appealing for the petitioner, my lord. On last occasion, lordship directed for issuation of citation. General citation has already been dispatched. I believe my learned friend is appealing for one.
Mukherjee, you were here.
With regard to special citation, I received it day before yesterday. My lord, I filed an application in 2021, my lord, seeking leave to file my Vakalatnama, to lodge caveat and to file affidavit in support of caveat. That is GA 1 of 2021.
Yes. Pending still now.
Pending still now. Now, my lord, since special citation has been issued, and I received it day before yesterday only. My lord, kindly grant me leave for 8 weeks.
What is your name?
My lord, Sunil Dhawan.
My lord, there are two non-consentees. One stays in United States of America, my lord. Probably
Mr.
citation.
Mukherjee appearing for Sonil Dhawan.
Yes, my lord, SONIIL.
Mr. Mukherjee appearing for the caveator.
My lord, caveat has not yet been lodged. I am seeking leave to lodge caveat.
Appearing for one of the sons of the testator or grandson.
Son.
Son. My lord, testatrix.
Testatrix, one of the sons of the testatrix. Submitted that special citation was received by him very shortly and prays for accommodation to file affidavit in support of caveat as well as caveat.
And my lord, to file Vokalatnama.
Leave is also prayed for allow him to file Vokalatnama. Leave is granted. GA1 should not be there any longer.
My lord, then my lord, accordingly GA1 may be disposed.
Yes. When it will come after vacation.
Yes, my lord.
The matter will appear in the list on 11 June.
And my lord, insofar as paper publication is concerned, I'm praying for some extension, my lord.
Paper publication shall be made in the meantime by the petitioner. GA1 of 2021 stands disposed of accordingly.
But the leave that has been granted to me, my lord, may I be permitted to file my Vokalatnama, caveat and affidavit in support of caveat?
In the department, leave is granted to Mr. Mukherjee. Vokalatnama along with caveat and affidavit in support of caveat may be filed in the department.
By 10th of June.
On or before the returnable date.
Yes. A copy of should be served, my lord.
Obviously, that is implied.
Item 13.
I think I'm happy for the petitioner. On the last occasion, the citation has been issued to the daughter of the executive. But as far as we know, that the address is not found.
A report is called for from the department on issue of citations, general as well as special, along with a report on caveat. The same shall be submitted before this court on or before 13 June.
Grateful, my lord.
Item 14.
For the plaintiff, your lordship.
Statement contrary to lordship's direction has already been filed.
We have not been served, your lordship.
Serve it. So now discoveries inspections. Additional written statement has already been filed. Semicolon copy served today. Discoveries, inspections, disclosure of documents as well as admission and denial of documents shall be complete on or before the returnable date. Let this suit appear in the list on 25th June.
Item number 15. In the goods of Chinmoy Kumar Maiti.
Last order ki chilo. None appears. On previous occasions also none appeared. Let the matter be dismissed for default.
Item number 16 and 17.
My lord, with regard to item number 16, my lord, I'm the plaintiff, my lord, your lordship has direct
Who filed J1?
file for amendment. We have carried out. I have carried out the amendment, your lordship, and I haven't served it. Yesterday, we have carried out the amendment. TA number 1835 is ready for hearing, my lord.
TA number?
1835 of 26.
GA1 of 16 say that is the old number.
That is the old number. And now at present, the number is, my lord.
Let me see GA1 of 16.
My lord, I will serve the respondents the amended copy.
What is the subject matter of suit?
I will serve. I will serve. I will serve, my lord.
Amended copy has not been
I will
served.
serve. Yesterday we have carried out the amendment, my lord.
Amendment of this application.
Amendment of this of the plaint, my lord, of the plaint, and I will serve. Yesterday we have
This
amended
is for
the plaint.
occupational charges.
Occupational charges and municipal charges occupying the premises, my lord. My lord, this is the suit is regard to the same, my lord, and I'll serve the copy and
The
later.
suit premises is being used commercially for commercial purpose.
Commercial purpose,
We
I
have,
have
my lord,
taken-
presently I am for the defendant number 8. We have vacated the premises, my lord, without prejudice. to
Whatever
the-
that might be, but this must be go to the commercial division. Check it.
It's the suit of 2000.
Suit of 2016.
16. Perhaps, my lord.
16.
No perhaps. There is no perhaps. It's the pending suit.
My lord, we'll check it and come.
2015 is the, my lord, commercial.
No. That's why I said this is a pending suit. Till 15th November 2018.
But there is a judgment of the coordinate bench, my lord.
Hey,
Lokhi Polyfab made it very clear, unless notification of specified value is there, suit is deemed to be pending. So it is filed earlier.
That will say many suits of the
And that judgment was upheld by the Supreme Court of India.
But it will come up on the next week, my lord.
Why come up on the next week?
Then we have to file a few affidavits, my lord, with regard to the commercial suit, my lord. That I'll do. I have to give.
Prima facie, this is a commercial matter.
My lord, the thing is that my lord, one decree has been passed in this suit.
Decree has been passed.
Yes.
There are two perhaps. My lord, only thing I will beseech whatever they want, my lord, kind.
My lord, decree
I am not
has
standing
been
on the
passed. Special
Kindly-
referee was appointed with regard to occupational charges. We have got the amount, part amount with regard to few, and
Preliminary decree is passed.
decree was
not
passed.
preliminary. Our decree has been passed in
That
favor
you-
of the
that you
plaintiff.
check.
In favor,
Yes,
in
my
favor of the plaintiff, so far as the client of my learned friend is concerned, because my learned
Mr.
friend is
Datto,
I'm appearing for
that
one
point
and
should be
also
checked
for
whether
the
decree is passed or
plaintiff
not.
because I have
defendant
no
one. Defendant
interest,
one.
clash of interest because there is no
Defendant
clash
number
of
1, my
interest.
lord, my learned friend.
Yes,
will
I'm
kindly
appearing.
record my learned friend's appearance. as-
Adjourning the matter, come on the next day.
There is no clash of interest. I'm appearing. I'm saying I'm appearing. হ্যাঁ, বল,
তো
বল।
plaintiff-এর হয়ে appear করছে, defendant এর হয়ে-
Yes, yes, yes. Oh, because they are
Very good.
my lease. I do not have any clash of interest with defendant number 1, my lord.
Our
Because they
take
have
that is a collusive.
they have given to him. You take that point.
They haven't.
You take
Anyway,
that
my lord, one deal.
You take that point because I do not have any clash of interest.
Adjourn. Check it, adjourned.
My lord, with regard to 2500, the next GA
Say the new number, not the old number.
2500 is 10, my lord. Your lordships had directed, my lord, pursuant to the
What is about what is GA10? That is 2500.
2500. With regard to 2500,
What is this application about?
my lord, this application was with regard to paying of mean profit, my lord. The order was passed with regard to the same. Thereafter, they had filed and
Come on the
recalling-
next date.
Well, it was heard. Your lordship, 30 seconds, my lord. Your lordship directed to file notes of argument. My notes of argument is ready. Only it is an admitted amount. They will pay some amount to us. This is admitted by both the parties. By the order of the Supreme Court direction, and your lordship has heard this matter.
Please stop now. Please stop. Yes.
এটাই নেই।
I am confused.
এটাই নেই।
That is the effort.
My lord, with regard to this application, he is not.
Adjourn to
My lord,
19
my
June.
my lord will hear
That's
me.
all.
It was heard, my lord, and
Very
your
good.
lordship
Adjourn.
directed to
I
file
am not
notes.
dismissing the application. It's adjourned.
My lord.
I am here not to hear you only, but to understand.
My lord.
That should be kept in mind.
Item 18 and 19. Arijit Das Mullik.
Oh, yes.
GA13 and GA14.
I am for the applicant. But you kindly looks at the order dated.
What is 13? What is 13? GA13.
13.
Milord, GA13 Milord is an application filed by the defendant who Milord has asked for stay of the suit. On the ground, what are the application? On the ground that the
ये 13
defense,
14 रुपए दो
I tell you not briefly. The suit was filed against me by 3 plaintiffs.
But we have to file an objection by learned friend's application for addition of party, not Mr. Dutt's application, but
अरे
the
दूसरे
other.
एप्लीकेशन दाओ ना
But we have tried to serve the affidavit in opposition. But
intervention application by plaintiff 2, that is 14.
that is 14. Now, my lord, to that we have to file an objection.
Just a minute, one by one. The other one 13. Hearing didn't. Have you applied for certified copy, anyone?
Not to my knowledge, Milord, I have
No.
Then why it's lying with the department? It should come today. Anyway, insofar as 13 is concerned, exchange of affidavit is complete.
My lord, the application of my learned friend for addition of party. That, my lord, affidavit in opposition was tried.
That is 14.
That is 14.
13.
13, my lord.
Addition of party.
Yes, I've seen this.
Milord, the reason why I say is this, Milord, the both applications need to be heard together because I'll tell you, Lordship, why. A suit was filed against me by 2-3 plaintiffs. My tenancy was terminated. During the continuance of the suit, one of the plaintiffs, Milord, have sold off his undivided share to my learned friend's client. My learned friend's client, after being owner of the property, Milord, sought rent from me and I have paid rent. So my defense in that suit, in that eviction suit, is that the notice of termination has gone because one of the co-tenants have taken, co-owners have accepted rent from me. In the meantime, we come to know that so far as this my learned friend's purchase of the property is concerned, that is being challenged by somebody in the city civil court, not client challenge করেছে.
No, citizen.
By Mr. Ghosh's client. And in that suit, a third party.
Yeah.
And that third party, Milord, in that suit, Milord, an addendum order of injunction has been passed, restraining my learned friend from exercising his rights as owner of the property or co-owner, because that conveyance is under challenge. My defense in 13 is that if my learned friend succeeds in his suit, if my learned friend succeeds in preventing his conveyance, then my eviction suit needs to be dismissed. The suit filed against me for eviction needs to be dismissed. So my defense in this suit, which I have already taken, is dependent on the outcome of another suit between one of the parties who is seeking my eviction.
That is pending in city civil court.
Yes. That suit is pending in city civil court. This eviction suit is before this court. This application for stay of the suit is before your lordship.
Anyway, so 13 is stay, application for stay.
For stay of the here suit.
Where is the application? Why it is not here on the date of hearing?
But we have a copy of the lordship.
That's separate issue. Exchange of affidavit is complete.
Yes.
No, Lordship.
No.
No.
So far as 13 is concerned, exchange of affidavit is complete. GA 13 of 24.
13 of 2024.
2024 is not placed before this court. Though this is a day of hearing, date of hearing. Though today it's a day of hearing. The department is directed to place the application before this court on the returnable day. Full stop. GA 14 of 2024 is filed praying for intervention in the suit.
In addition of parties.
Is an intervention application filed by a stranger. Affidavit in opposition shall be filed.
It's already ready.
Is filed today.
Lordship, I have received it much later. I have received it on 20.
You are for?
I am for the plaintiff.
For the plaintiff. Let the same be kept in record.
I need another 2 weeks. I'm for the applicant. The intervener.
Intervener, what intervener will do here?
Absolutely, my lord.
You
And
are not even a party. You have no locus standi to file objection.
but his application, my lord, that
It's my application, Lordship.
is his application.
So far as GF14, yes. So you have to file reply.
Yes.
Any other AO?
No, my lord.
Not to my knowledge.
No, my lord. Nobody can.
The learned counsel for the intervener craves leave to file affidavit in reply. The same shall be filed on or before the returnable date. Both the applications, namely GA 13 of 24 and 14 of 24, shall appear in the list. Two suits are there.
No, my lord. Suit
Okay.
is one. Suit is one. But kindly gives us 1 day before the vacation because, my lord.
No, I'll not be over there. I'll not be over there. I'll not be over there.
You will not be over there
No, I'll be in Guwahati.
from tomorrow till 20.
No. From I'll be going on 16.
16. So what? 14 days your lordship is giving us. So come back on 15th, my lord, if it your lordship, my lord,
15th is
diary
okay.
permits.
14th.
14th or 15th.
Keep it 16th May.
16.
16 is okay.
65 Lordship, I'll not be over there.
He is
Oh.
not the 16th, my lord. 15th or 14th.
14 is okay.
Okay.
Keep your
Item 20 and 21.
My lord, in this matter, Senior Advocate Manju Agarwal is occupied in another court, court number 23. Kindly pass over the matter.
Have any objection in that? There are two applications. One is the plaintiff application for occupational charges. One is the defendant application for the extension of time to file written statement. But we are conceding to the defendant's application. Let them file the written statement.
Come at 2 p.m.
Proceed. But 2 p.m. there are two fixed matters in different. Then tomorrow we will take note.
Tomorrow, not today. Let Ms. Agarwal appear.
application.
My lord will recall that on the last occasion, my lord had.
What is GA4?
It's our application.
Application seeking
to file-
recording of an order by which my lord
file
the
written
suit was
statement,
directed. There's possibly
And
no
my
way
lord
of
had
filing.
indicated to
Which is the order?
let, that would be on the
23rd
23rd of
July.
July 2024. And on the last occasion, my lord had indicated that let it be prepared.
You have for defendant number 1 to 4.
1 to 6. All
One
of them.
to?
Not all of them. The application has not been filed by all of them.
This application relates to except 5.
Except five has not filed.
But we are ready.
My lord, I have to
We
make
are
some
ready with
submissions because I'm seriously objecting to this prayer. There are reasons.
Any AO?
Yes, I filed my affidavit in opposition.
What are the grounds?
It
What?
was all on the.
What are
former
the
law-
grounds?
On the former lawyer. We had all
Where have you stated this?
at para, my lord. 7, that would start from paragraph 6, 7, and 8. And my lord will see that they even made an appearance on 16/2 and 2022.
Subject to payment of cost.
My lord,
Only hears me out
my-
because
please,
there is some
I'll explain
ground
why
take-
costs should not be imposed on this. Just give me a second. My lord, the whole matter relates to Rajasthan. All the plaintiffs, even the defendants, they're all residents of Rajasthan. They have been dragged here in Calcutta without clause 12 leave yet. And without that, they have proceeded so far to make the case undefended. That is surprising in itself. Now, my lord, it's a case of defamation. The publications were made in Rajasthan. The land on which those publications were made are based in Rajasthan. The newspapers who made these publications are Rajasthan based. They are
Whatever
regional-
that might be, raise this issue at the time of hearing.
That's the reason, my lord.
Jurisdictional issue. Raise this jurisdictional
we
issue.
will do that, my lord. But at the moment, we just want permission to file our.
According to you, for the timing, this is the reason why cost should not be imposed.
Yes, it was all on the former lawyer because
All
they
right,
had all the
yes.
instructions there.
My lord,
And
first-
they all live in Rajasthan.
The only ground taken is fault of a lawyer. My lord will first see the petition. What are the prayers? Because the copy that has been served, there's only other prayers have been struck off. There's only one prayer which is there.
the order dated 23rd July 2024 be set aside and are recalled and are modified to allow the defendant 1 to 4 and 6 to effectively defend in the suit by proceeding with appropriate application or response to subsequent filing of the plaint by the plaintiff. There is no prayer for even extension of time to file written statement.
That comes later, my lord.
Kindly, please don't interrupt.
What had happened
Please don't interrupt, sir. I did
in
not
the
interrupt.
beginning, that should be focused.
Should I hear you only?
No, of course, my lord.
Then please stop.
That's what. Now, my lord will see the pleadings as to fault of advocate from paragraph 6 onwards. Paragraph 5, appointment of advocate, 15th of February 2022. Strangely, all the defendants 1, 2, 3, 4, and 6 engage advocate on the same day. Very well, no difficulty. Now, my lord kindly comes to paragraph 8. Then again, on further contact, I'll just read out this paragraph, my lord. Then again, on further contact, the learned advocates engaged inform the defendants concerned that a petition or application was required to be filed in the matter, and soon a date for their travel to Calcutta would be communicated after the preparation of draft petition. After a period of wait, the defendants concerned contacted the advocates engaged. So there are multiple advocates, multiple defendants, and expressed their displeasure for having to wait and having not heard from them as to when the said petition application was finally going to be filed by.
All right, noted your objection.
No, my lord, there's one more thing. They had filed a transfer petition to the Supreme Court. In my opposition, my lord, I've said that completely. This fact has been ignored in the application.
And there was
Transfer
a
petition.
Please.
Kindly seize, my lord, the transfer petition in the opposition, page 54.
Page?
Page, my lord, 54, my lord.
Yes, yes.
Transfer petition starts. And, my lord, we'll see page 85.
Page 53, second volume.
Page 54, it starts.
Page 54.
Of the affidavit in opposition, my lord, the transfer petition starts in the second volume. They seek transfer of this suit to Rajasthan before the Honorable Supreme Court.
Yes.
Now, at page 85, kindly seize their averment. That the averment is that the written statement has also already been filed. And they annex a copy.
Yes.
Now, they gave an affidavit. So this story, they gave an affidavit, page 174, to Supreme Court, and this kindly note the date of 12th of February 2024. Stating that they have and kindly sees this. The petitioner had got a written statement in the civil suit drafted by his counsel, who was looking after the matter pending before the Honorable Rajasthan High Court. Even settled by the senior advocate, has been leading the matter before the said written statement was given to the learned counsel for Kolkata for filing before the Honorable Court. Went on Kolkata on 5th February 2022, and between 5th February 2022 and 7th February, met his then counsel, Mr. Surendra Dubey, who handed over all papers to Mr. Ajit Kesari, advocate. That therefore the petitioner had having given a copy of the duly prepared and settled written under the bona fide belief the written statement had duly been prepared and filed. On the basis of bona fide belief that the petitioner instructed his counsel in Delhi that the written statement has already been filed. Now, apropos this, kindly see the story that they have made out in paragraph 8 of the petition. Before Supreme Court, they say that in 2020, between 5th February 2022 to 7th February 2022, met the counsel and handed over all papers. And then thereafter, the story is that no, there was I called up. They were not. They were angry. They put down the phone. That's why we got a change of advocate. Now that this transfer petition was dismissed on 13th February 2024, which is at page 50, volume 1.
Page 50.
Page 50, my lord, volume 1.
Yes.
50 volume 1. This is an order dated, my lord, 13 February 2024. So 13 Feb. So before that, they were aware that they made a misstatement, written statement being filed. Nothing done. 13 February transfer petition dismissed. Now, then the application has been taken out. Kindly sees when. The application. Yes, the application has been affirmed on January 2025.
After 1 year.
After 1 year. From Supreme Court, they went to Supreme Court dismisses, and the only ground taken is a learned advocate did not speak to me properly over phone when I called up. I'll just show one judgment which said that the mistake of advocate or fault of advocate is not a ground for extension for written statement, because that's the only ground which has been made up. And plus there is misstatement, transfer petition, all these facts and all completely ignored. Complete misstatement. One thing stated before the Supreme Court and something else completely made out.
All right. Now you tell me your submission.
My lord,
one judgment, my lord, may I just
on that same bundle, please come to.
Your affirmation before the Supreme Court was written statement was ready.
Yes, and that was on
Is
the
it ready now?
Yes, they are.
When will you file it?
Just give us 1 week and we'll file it. It's ready. I can even show, my lord.
GA4 of 25 is filed. Praying for recalling the order passed by this court on 23rd July 2024. In terms of which suit was marked as undefended against defendant number 1 to 4 and 6.
My lord, we are even.
The instant application
5, they have not been an application.
Contains a prayer to recall the order and allow the petitioner defendant to file written statement. Full stop. Next para. AO is filed. Mr. Bhattacharya, am I correct?
Yes, my lord.
Vehemently object to the application.
May I take my lord's leave, my lord? There's one matter getting great. My junior is here.
Judgment?
Yes, 2008. My lord,
All right, you may go. Vehemently oppose the objection application on the ground that an unsuccessful attempt was made by the plaintiff, by the defendant, present defendant, to transfer the suit to Rajasthan. It was stated in an affidavit filed before the Supreme Court that written statement was ready. Full stop. According to Mr. Bhattacharya, in spite of such affirmance, they did not care to file the written statement. And delay is not for the laches of the learned counsel, but a deliberate one. Judgment. It is further submitted by Mr. Bhattacharya that although a ground is taken that laches of the advocates are reasons for inability to file written statement, such a ground should not be available to the present defendants. Mr. Bhattacharya relies upon Koilash versus a Bananta dekhe niyo. Nanku to fortify his argument. Full stop. I have heard both the counsels. After hearing both the counsels, this court thinks that it is in the interest of justice, the defendants should be allowed to file written statement within 1 week. However, subject to payment of cost of rupees 25,000 with the High Court Legal Services Committee. Full stop. The suit will appear in the list. On 14th May, payment of cost should be made beforehand. All right.
My lord, we haven't filed application in relation to defendant number 5, but we are ready with.
Defendant number 1 to 4 and 6.
May we be permitted to file defendant number 5's witness statement, written statement as well?
File the application, then let me consider. Come on the next step, file application appropriate then, because time has expired.
Could it be reduced to 15,000? Because they are frugal, they are just
No.
social workers. They are
No.
not.
Next,
I'm grateful, my
this reduction is not to pay to the plaintiff, but to another social organization.
lord. I'm grateful.
GFO stands disposed of.
My lord, in this matter, Senior Advocate Manju Agarwal is appearing for the plaintiff.
On prayer of Learned Counsel for the plaintiff, hearing is adjourned to 13 June.
13 June.
13th June.
Oblige, my lord.
24.
For the plaintiff, my lord, this suit for partition, my lord. On the last occasion, the partition commissioner has already supported his report, my lord.
Who is the partition commissioner?
I appear for the partition commissioner.
Report is there?
Report is there, your lordship, but however, after the report has been filed, may I indicate only one thing. The engineer who was appointed by the commissioner of partition has given a letter saying that there is one mistake in the drawings that he had submitted. May I hand over the letter?
No. So do one thing, file a supplementary report.
Your lordship, it is one drawing. I can just hand over the report and the drawing can be taken as a part of the report.
Court will not be able to understand that drawing, meaning of the drawing. So submit a report. A leave is granted to file supplementary report to the Learned Partition Commissioner. How it is related to the matter, how it is related to the property, that should be there.
May I make only one more indication, lordship? Your lordship had indicated that 50,000 rupees had to be paid.
Come on the next day, I will reconsider. Some more will be paid. The suit will appear in the list for furnishing supplementary report on 28th June.
Grateful to your lordship.
25.
My lord, this is my application, my lord. I'm the plaintiff in the suit, my lord. This application has been heard in part, my lord. The defendant, my lord, appears on some days and not on some days, my lord. The application is pending for over 6 months, lordship.
What
This
is
is my
GF1?
application. My GA1 is
for the respondent. Actually, there is a bereavement in the family of the
Which
advocate
application?
or-
GA7?
Yes, ma'am. This
Playing
is
for
for my transfer to the commercial division, my lord. My lord was already almost convinced, lordship. It is my application is based on lordship's notification as well, my lord, for declaration of specified value. But my lord,
Specified value was notified by the government.
yes, my lord. But
That
my
is on
lord, it was-
15/11/2018.
My lord, on 15, yes, my lord. That was my lord signed by your lordship, and lordship was
No,
presiding as
that
the-
was by the Joint Secretary of the Government of West Bengal.
No, that is at page 29, lordship.
Yes,
By
that is the notification.
Yes, 15 November 2018, lordship. And my lord, my suit was filed on
Constitution of the Commercial Division.
Yes.
That was done by me.
Yes, my lord. Yes, my lord. I stand corrected, lordship. I'm sorry.
Specified value should be done by the appropriate government.
Yes, yes, my lord. That has been done, and lordship's notification is at page 28.
Not lordships, the registration's notification. Yes.
My lordship, actually,
When
there's
the suit was filed?
My lord, July 2018, lordship. It was before the notification of specified value.
Giving you 7 days time.
my lordship. If there is a 14, if you allow us for 14 days time.
How many? 7 days. My lord,
19? I will hear this on that date.
Great.
Whether you come or
Great.
not.
Great.
An accommodation is sought for by the Learned Counsel for the defendant. Accommodation is given. The application, namely GA1 of GA7 of 24, will appear in the list on 19th May. Adjournment given is peremptory.
Grateful, my lord.
I'm grateful, my lordship.
Because this will be deemed to be a pending suit.
Yes, my lord.
Till 15/11/2018.
Yes, my lord. My lord, they have taken only one point, my lord. They are relying upon the notification of a 3rd May 2018. But my lord, my learned friend is saying that that notification only specifies the value. But my lord, that is not the case.
Where is that notification?
My lord, if lordship, that notification, my lord, is not there. The amendment reflects in the act itself, 31A. But that is not, the language is very clear.
Dokhi Polyfab is very clear.
Yes, my lord. Yes, my lord. Absolutely.
That was upheld by Supreme Court.
In party automation, lordship. Grateful, my lord.
26.
Lordship, this matter, there was a direction to file this the evidence, judge's brief of documents, Lordship, that some documents were seized by the CBI, Lordship. So there, the office was shifted. Due to this, they were not supplied this the copy of the documents. So
Taking for time.
taking for time, the Lordship.
Now adjournment is sought for.
Kindly provide us.
Let this suit appear in the list on 4th July.
Item number 3.
My lord, I appear on behalf of the defendant numbers 1 and 2. My lord, by the case, my lord, the defendant number 1's counterclaim, my lord, has to be adjudicated by your lordship. On the last occasion, my lord, I had told your lordship, my lord, that my claim was counterclaim was in respect of a sum of rupees 15 lakh, which was admittedly advanced to the plaintiff number 2 by the defendant number 1. Matter went into a winding up proceeding. Petition was admitted out of 15 lakh for an admitted sum of rupees 13 lakh. 2 lakh relegated to suit, because there was some dispute whether 2 lakh had been paid, on what account it had been paid, whether it was towards interest, whether it was towards principal. They went up in appeal before a division bench. Division bench dismissed it. Then they went up before the Supreme Court. Yes. And Supreme Court said that for the time being, the disputes are resolved. The whole issue,
for the time being.
For the time.
That is your point of argument.
For the time being, and the suit was expedited.
A stopgap measure.
As a stopgap measure, and the suit was expedited. This suit was expedited. So obviously, my lord, since the suit was expedited, all the disputes were not resolved. Moreover, what is most important, my lord, kindly bear in mind, my lord, what was the subject matter before the Supreme Court? The subject matter, my lord, was a winding up petition. Scope of a winding up petition, my lord, is
to stop winding up, this order was passed.
That's right. When I file a winding up petition against a party before the court at that point of time, under section 434 of the Companies Act, my prayer in a winding up petition, my lord, is that the company should be wound up because it is unable to pay its debts. My winding up petition is not a claim. It is not a monetary claim. So therefore, no monetary claim was at all settled before the Honorable Supreme Court. So my learned friend has argued that all your claims, all your disputes have been settled, you have abandoned your claim, etc., etc. Kindly see, my lord, what was the scope of the dispute? It was only with regard to winding up. That issue of winding up was resolved by me taking 10 lakh and him taking back 3 lakh out of the 13 lakh which was deposited. So if I were to file another winding up petition on that same cause of action, that I am stopped, that I am precluded, that I am prevented. But I am not prevented from filing and getting my monetary claim adjudicated before this court. That is my simple point. So out of 15 lakh, therefore, my lord, 5 lakh in terms of principal stood outstanding. That has now gone up substantially in view of interest at the rate of 24% per annum. My learned friend had raised a dispute that interest was not 24% per annum, but it is an admitted case in one of the CRRs which they had filed before this court in respect of the same transaction. There is a categorical admission by them that yes, they had agreed to pay interest at 24% per annum. Initially, it was 12. They wanted further time to repay, so it went up to 12. Then again, they failed to repay. Then it went up to 24. So that also is an admitted position. And the CRR order, my lord, Justice Joy Sengupta's order, my lord, passed, my lord, kabe? 2019 order. In 2019, my lord, there's an order of Justice Joy Sengupta, my lord, of this court, my lord, where he takes, my lord, cognizance of the Supreme Court order, takes cognizance of all the transactions between the parties, the interest also rate which was agreed at. And his lordship, my lord, was pleased to record specifically that the parties had not settled their dispute so far as my monetary claim is concerned. So there is already, my lord, on the record of this court, an interpretation of the judgment of the Supreme Court. So therefore, the section 138 proceedings also proceeded.
I understand
there
your
was a
point.
condition. I have, my lord, revised my written notes of arguments. Lordship had indicated that I should revise the same, and I may be permitted to file the same.
Any reply?
Well, just 2 more minutes, my lord. Just 2 more minutes I'll take, my lord, so far as reply is concerned. I'll just place section 434 of the Companies Act. Just, my lord, to show what the scope is of a winding up petition. 1956 Act, not the 2013 Act. I don't know which act your lordship has. Lordship has a 56?
Yes.
Section 434, the heading, my lord, company when deemed unable to pay its debts. 434(1), a company shall be deemed to be unable to pay its debts if a creditor, by assignment or otherwise, to whom the company is indebted in a sum exceeding 1 lakh rupees then due, has served on the company by causing it to be delivered at its registered office by registered post or otherwise, a demand under his hand requiring the company to pay the sum so due, and the company has for 3 weeks thereafter neglected to pay the sum or to secure or compound for it to the reasonable satisfaction of the creditor. B, if execution or other process issued on a decree or order of any court or tribunal in favor of a creditor of the company is returned unsatisfied in whole or in part, or if it is proved to the satisfaction of the tribunal that the company is unable to pay its debts, and in determining whether a company is unable to pay its debts, the court or the tribunal shall take into account the contingent and prospective liabilities of the company. So that section 434 is this, and section 433, my lord, kindly take 433, circumstances in which a company may be wound up by a tribunal. Kindly take 433. A company may be
basically it will come to E.
So the limited scope, my lord, of a winding up is that whether the company should be wound up or not. It is not a money suit. It's not a recovery suit. So therefore, the
more drastic remedy.
Much more. And now before the NCLT, we have the IBC. Now the 434, 433, the concept has been totally eradicated. Now we file for my lord CIRP and thereafter liquidation if the company is not resolved. There's no resolution process. Now let's just kindly take the note which I have handed over today, just to show my lord the order which I referred to. It has been exhibited also as Exhibit G, but for your lordship's ease of convenience, I have annexed it. Kindly take page 22 of this note. This was passed, my lord, in the CRR, 13 September 2000.
Para 6.
Well, kindly have one paragraph before that. 24%. Para 2 page. Can you take para 20, page 23? The fourth last line from the bottom, my lord. The petitioner verbally negotiated to pay interest at 24%. And this was specifically recorded in their petition because
this is in respect of dishonor of check.
This is in respect of dishonor of check of 15 lakh and the rate of interest in respect of that. And now, my lord, para 6, as your lordship has been pleased to point out, from a careful perusal of the order passed by the Honorable Apex Court, it is quite evident.
But it is in reference to the criminal case.
That's right, of course. But the same facts are being discussed.
Right, same fact,
and
but so far as compounding is concerned, this is in view of compounding.
That's right. And my lord, so my lord, the order is also discussed.
Does not wash away offense.
Yes.
This is the vital point.
Correct, absolutely, my lord. And kindly, my lord, see, my lord, paragraph 8. No,
yes, paragraph 8, it's settled law.
Yes. It does not wash away. And 7, my lord, will also take
compounding on offense. That was that decision was given in respect of a criminal case.
Yes. And kindly see the last sentence in para 7. Even the purported due was not paid. The entire purported due was not paid.
That is in the Supreme Court order itself.
Yes. So only 10 lakh
no
was
dispute
paid,
on that.
5 lakh remained outstanding. Cost sheet. Show me the calculation sheet. Kindly take my page 82, which is my calculation sheet, updated calculation sheet as on March 31st, 2025. Just explain, my lord, the figures for a moment, your lordship. That has page 82. And the right on top, my lord, is the principal amount, which is rupees 15 lakh. Then, my lord, I have calculated interest from 24% at the rate of 24% from the date this third extension took, from 21st July 2012 to 7th October 2013. So that comes to 4.
So your total claim 35, 22, 255.
As on March 31st, 2025.
Okay.
So 15 lakh was the principal. Then to 7th October 2013, my lord, 4 lakh.
Suppose the claim succeeds. Then this calculation is to be accepted. Till 31st March. You claim till 31st
March. And thereafter, my lord, interest subsequent to that, my lord. Kindly see, my lord, the date is also relevant. On 8th October 2013, against para C, column C, I have received 10 lakh.
Yes, that is there. I saw this.
So then it comes down to, my lord, 9,37,000
plus interest. Then
interest I'm calculating at 24% on this 9,37,000.
All right.
And my lord, I have also, my lord, prayed for costs, and the Commercial Court
and other things
allows me the same, my lord. In fact, there's an order passed by Justice Showman also in this matter, which is at the judge's brief of documents at page 116, where he also specifically records. I'll just place the same. I've mentioned in my note.
Is it here?
It's in the judge's brief of documents.
Here?
No. The order is not there, my lord, but I'll just read it out.
Come with that one.
It is there. कौन page है? Can you take page 161?
All right, I will check it.
I'll just read it out, just a short line, my lord. It is there, my lord. Kindly take my word for it. Yes. Since the claim of the defendants is now fully secured on an undertaking given by the plaintiffs that they shall compensate the defendants in the event the suit is dismissed, the plaintiffs shall be allowed to resurrect their claim and the order, etc. So there's a specific obligation on their part, my lord, to compensate me in the event their suit gets dismissed. Their suit, my lord, they're not pressing any of their claims against the defendant number 3. Because they're not pressing their claims against the defendant number 3, they are unable to press their claims against me. So what is alive today before your lordship is only my counterclaim. So their suit has to be dismissed in any event. As a result of which, pursuant to the undertaking given by them before this court, which Justice Sen has recorded, they are liable to compensate me. And I've also, my lord, given my cost sheet, my lord, at page 54. It's an affirmed cost sheet, my lord. It's in the form of an affidavit where I've given my cost sheet, my lord, to show what are the expenses which have been incurred by me, including court fees, counterclaim, and lawyers' fees. That also I've indicated. And order 23, my lord,
Like
I've argued
reply or
last
I fix another date.
My management wants me to, but then
this will be a reply to a reply.
I'll take it.
It's my counter.
I'll take this as a judgment, as a precedent which has been cited, and I want to deal with that. The order of in the criminal case, because otherwise I don't think.
I'm not concerned with the criminal case here because this is a civil suit. That judgment was given in the context of compounding of offense.
No, quashing.
No, that was there's a reflection on compounding. Whether the suit can
be compounded.
It can be compounded. Offense can be compounded on all those things.
I have to deal with, my lord, the legal submission pertaining to the scope of 434 winding up petition, and also whether, my lord,
I am not hearing a 434 application.
Yes, but then the submission has been that since it's a subsequent winding up petition would have.
Your understanding, basically your understanding, because your understanding is, I thought suit was disposed of. I thought suit was compromised. Why did you think that?
The question is that it is not really about what the Supreme Court order says. On the day when the Supreme Court order was passed, there was no counterclaim on board. The suit, it was only my suit against the defendants, where my principal claim.
Counterclaim can be filed at any time.
Exactly. So there my point lies that the issue is not the relief claim. In a winding up proceeding, it is that he has asked for my liquidation, my winding up, based on certain facts or a cause of action, against which he could have opted for a suit. He did not file a suit. He opted for winding up. Now that goes for settlement. Once that is settled, out of 13 lakhs, 10 lakhs, settle that he'll get 10 lakhs and I'll get that 2 lakhs. So once that happens, then there is nothing mentioned in the order that he has liberty or leave is granted to him for the balance claim to proceed in a different proceeding.
So, argument is there?
I have.
I am reserving it.
Grateful, mother.
In this matter, my lord, I made the defendant number 3. This was the fighting between the plaintiff and the defendants. Falsely, I was implicated to avoid the payment of the defendant number 1 and 2 by the plaintiffs. Since 2012, so that I am entitled for the course, my lord. I will defend number 3. Yes, definitely I will entitled. I am fighting this because I am fighting this. I am not asking one to do crore. Whatever your lordship providing it, the defendant is fighting it, my lord. All litigation was against me.
Item number 4.
I am the defendant, man. No, no. No, defendant has completed the argument, but
Who has completed that?
yes.
One has not completed that.
No, no. We are for the 1 and 2. There is 3, I think. No? Only defendant. There is only one defendant, madam. Mr. Chaudhary has, Sabyasachi Chaudhary has, yes. So we reserve our right for the reply, my lord.
Let me conclude, then my learned friend will reply. My lord, your lordship will remember, I had started.
I was confusing it with another matter.
Yes, I could understand. But your lordship remembers, I was saying on the question of willful default. Now, my lord, so far as my lord's forensic expert report is concerned, the forensic expert report said that, my lord, inlet valve had been closed and so on and so forth. I shall come to that. But, my lord, on the policy, I had shown your lordship that the exception to the policy was clause O. And clause O says that willful action or willful default. Now, my lord, willful action is a, my lord, deliberate act. They have said that there is no arson. So, my lord, willful act is ruled out. Willful default, my lord, according to, my lord, the judgments that we have been able to find, is, my lord, when there is a, my lord, strict duty to act and you deliberately do not act. My lord, which means, my lord, you turn a blind eye. My lord, that is the language used by the courts. That, my lord, you can see that this is what is going to happen. So, my lord, apply the doctrine of reasonable foreseeability. And in spite of seeing that what is likely to happen, you turn a blind eye. Now, my lord, it is not their case in the pleadings that, my lord, such was the situation. Now, my lord, my learned friends will not be, my lord, allowed to prove a case that they have not pleaded. That is very fundamental to our jurisprudence. So, my lord, in the absence of any pleading, and I showed you, lordship, from the plaintiff what is their pleaded, from the written statement what is the pleaded case, my lord, they cannot even venture to prove this point. Now, my lord, so far as this is concerned, I had, my lord, briefly showed you, lordship, the witness action on this point. My lord, the defendant examined 3 witnesses. My lord, the first was, my lord, the
Suman Bhagat.
Suman Bhagat. My lord, very briefly, if your lordship will just turn to questions 39 onwards of Suman Bhagat's, my lord, deposition. Can you identify the specific terms, conditions in the policy which, according to the defendant, has been violated by the plaintiff?
Question number?
Question number 39. Your lordship will recall, my lord, we are talking about exception O, which is in the judge's brief, volume 1, my lord, page 87. Well, I'll just read it out for your lordship's recollection. Loss or damage directly or indirectly caused by or arising out of an aggravated by willful act or willful negligence. Now, my lord, the cross-examination from question 39 onwards, your lordship will see. Well, for example, question 40. Is it your evidence that without looking into volume 5 of the documents that you have just referred to, you cannot say what are the terms and conditions?
So answer 42, question number 40, deliberate act.
Yes, but my lord, how it is deliberate, there is no pleading. My lord, using an adjective will not, my lord, make a difference. You have to establish. Now, my lord, please see.
Now, what about your evidence about the inlet valve?
Yes, my lord. My lord, so far as, my lord, there are 3 things that I have to show it to you. One thing is, my lord, on the willful part. My lord, 3 witnesses have all, my lord, said, my lord, that there is no, my lord, willful.
No, that you said.
Then, my lord, secondly is on, my lord, the standard operating procedure, because the standard operating procedure was violated.
You are following the standard operating procedure prescribed by the manufacturer.
There is no standard operating procedure, my lord, on record for the purpose of, my lord, filling, my lord, diesel into the mobile harbor cranes. Now, my lord, so far as this is concerned, my lord, if your lordship sees, my lord, Mr. Suman Bhagat's, my lord, examination on this aspect of the matter, please see question 55. Well, questions 55 to 61. Well, particularly if your lordship sees 58. Well, they did not even ask for any standard operating procedure.
58.
Yes, my lord, if your lordship sees, my lord, question 55 first. At the time of the first issuance of the concerned policy or at the time of its subsequent renewals, did the defendant call upon the plaintiff to provide to it the manufacturer's SOP? The defendant is not such bound duty bound to do so. However, to conform to this, I need to revisit office records. Then can you answer this question upon consulting records? Answer is no, I need to check the underwriting policy. Then are you aware as to whether the SOP of the equipment was sought either by the surveyor or by the forensic expert at the time of investigating? I think the affirmative that it was sought by surveyor. He thinks, but I have to recheck this. Kindly look at the final survey report and the forensic report and point out from the same as to whether the surveyor or the forensic expert had called for the manufacturer's SOP. Then he's shown the documents. My lord,
Question 58 is SOP.
Yes, my lord. 58, 60, 61, all SOP. And then, my lord, if your lordship sees, my lord, my junior wants your lordship to also have a look at question 44. No, inlet word pore aschi. Don't confuse. Then, my lord, please see 69. Kindly have a look at your answer to question 61. Did the surveyor or the forensic expert point out in their respective reports as to whether and if so what departure had been made by the plaintiff from the crane user manual or any of the documents? So, my lord, SOV. My lord, there is no answer. Then, my lord, question 70. I take it that neither the surveyor nor the forensic expert found that the concerned MHC had been operated in departure of any of the terms of the user manual which was provided. From my answer to the preceding question, it is clear that the SOP has provided and other safety norms were not adhered to, which resulted. As regards the departure from any user manual, I cannot make any comments. So, my lord, he does not say what is the SOP. He does not say what is the departure. Well, he says there's a departure. Then 71, please see. Which part of the SOP as provided by the plaintiff was not adhered to? Witness refers to volumes of the judge's brief. As is evident from the forensic report of the safety engineer to the plaintiff, did not keep BC-type fire extinguisher and had to rush into the storeroom to prevent the spread of fire. Secondly, as a safety engineer, he did not remember to make any model of the pump, which he was expected to know, and this was particular motor did not comply with safety requirement, as it meant for pumping water only and not suitable for inflammable fluids, such as HSD. More so, he could not say whether the hoses were complying with safety norms, which as safety officer he is expected to use only machines and accessories complying with stringent safety norm. All these inferences of forensic expert are made vis-a-vis statement of plaintiff safety and electrical engineer Mr. Shobhi Karam. Pausing here for a moment, he does not say, well, what are the standard operating procedures? Well, which of them have been violated and how? He, my lord, makes random, my lord, observations with regard to, well, did not keep BC-type fire extinguisher, had to rush to the storeroom to prevent spread of fire, did not use any particular make of pump. Now, my lord, there is no prescribed make of pump. And, my lord, your lordship will remember, I am supposed to, my lord, take due care with regard to the insured equipment, which is the crane, not the pump. And then please see 72. I take it that therefore your evidence that the violations that you have just now alleged are not a part of the user manual of the machine or any manufacturer's SOP of the same, but alleged representations made by the plaintiff's person. I would like to reiterate that the plaintiff did not submit manufacturer's SOP despite surveyor's request. So, Mala, there is no question of comparing with the SOP. And, Mala, there is no surveyor's request for the SOP. How, according to you, is a printed procedure for operating a machine different from user manual? This question involves technical things I can't answer. Then 75, I am suggesting to you that no part of your evidence in this proceeding is your own. You've only proceeded to repeat without application of mine or independent scrutiny what the survey and the forensic expert have stated. Well, he says I disagree. Then, my lord, this is the first witness. Then please see, my lord, respond number 2. My lord, my lord, defend number 2, my lord, DW2. DW2, I'm sorry. Question, my lord, 195 onward.
Specific type of pump.
Yes. Did you inquire as to whether the manufacturer had specified the use of any particular type of pump for refueling of the crane? We did not find any specified type of pump by the manufacturer. But the fueling purpose of any of the other undamaged MHC of the insured, they brought a different type of pump, that is centrifugal pump with steel or iron body and driven by electrical motor. So, my lord, manufacturer did not specify any type of pump. After that, your lordship will kindly see a few other questions. I don't think I need to trouble your lordship with anything, well, so far as this is concerned. Then, well, the forensic expert. This is important.
Just a minute.
DW3.
Just a minute. Yes.
Well, now please see DW3. Well, question number 85 onwards.
Page?
Well, this is DW3, page 276 of the compilation of depositions.
$276.
Well, 276 of the compilation of depositions. So I think question 85 of DW3.
You're referring to 85?
Yes, ma'am. Apart from the mention of user manual at page 28 of your report, do you find any reference to or reliance on such user manual at any other portion of the report? Even though I have not quoted from user's manual in any other page, I relied on the user's manual wherever I found it necessary. Can you indicate from your report where you may have found it necessary to rely on the user's manual? Specifically, I cannot indicate where this user manual was relied upon. In which regard, during the course of your forensic investigation, would information in the user's manual have come handy? It is not possible to state where exactly I have used or relied on the user's manual. Let me put it differently. Did you ask for a copy of the user's manual of MHC1? It is the duty of forensic expert to gather as much information as possible in a scene of fire incident, whether it is useful or not. So it does not answer the question at all. Does your report demonstrate whether you found any portion of the user's manual to be useful? No. Do I take it from your answer that you did not find anything useful in the user's manual to support your conclusion as reached in the report? It is not true, but it does not say why. Then 91, in that case, kindly demonstrate from your report as to which part of the user's manual was considered by you in reaching your conclusion in the report. I considered it macroscopically and hence I cannot answer. Then please come to question 102. Did you go through the daily information and maintenance checklist of MHC1 or the copy of the maintenance checklist which you have referred to in serial number 5 and 6 under the heading documentary evidence collected at page 28 of your report? Yes. Did you find in the course of your investigation that the plaintiff had departed in any manner from the maintenance checklist of MHC1 in the course of refueling on 27th April 2019? To the best of my knowledge, the maintenance excluded the refueling part. So, my lord, the user's manual did not mention anything about refueling at all. Do I take it from your answer that you did not find that there had been any departure on the 27th April 2019 from the user manual or manner of operation or maintenance of the checklist of MHC1? The copy of daily information and maintenance checklist of MHC1 and MHC2 were from 1st April 2019 to 26th April 2019. As fire incident occurred on 27th April, that record was not furnished to me. But my lord, he is supposed to say, my lord, this is the user's manual, this is how you have departed from it. So the standard operating procedure has not been followed. Then in the course of your inquiries made on 23rd July 2019, did you attempt to inquire as to whether the maintenance and operations of the crane have been carried out in the same manner on 27th April as it had been done from 1st April 2019 to 26th April? The fire incident occurred in the morning of 8:50 a.m. on 27th April 2019. As such, there are no maintenance to come into the picture. The 106. I take it that you are aware that MHC1 and MHC2 at the plaintiff's site were in operation since 2016 and had been regularly refueled between 2016 and 27th April 2019. Yes. Did you inquire as to what was the method or manner that was followed for refueling MHC1 over the past 3 years? Yes. Did you find that the method of manner of refueling MHC1 over the past 3 years was different from the method adopted on 27th April 2019? Yes, they were following more or less same procedure. Did you inquire as to whether the manufacturer of MHC had specified the use of any particular type of pump for undertaking refueling exercise? Yes. Now, my lord, kindly note this. However, OISD, that is Oil Industry Safety Directorate, Government of India, Ministry of Petroleum and Natural Gas, has given specifications of the pumps that are to be used and meant for refueling HSD. Now, well, I shall come to this circular. So I take it from your answer that the manufacturer of the concerned MHC had not specified as to what type of pump should be used for refueling the MHC1. I am not aware. Did you make any inquiry as to how the several other MHC operators in the port area were refueling their MHCs and as to what type of pump they were using for the purpose? Answer is no. So, my lord, here, this, my lord, conclusive proves. Now, my lord, comes the question of, he says that, my lord, I have made an inquiry that the OISD, that the Oil and Industry Safety Directorate, Government of India, had given specifications for the pumps. Now, my lord, may I show to your lordship, my lord, the director of the OISD?
Is it in evidence?
It is not in evidence. It's a part of my argument. My lord, his evidence, he says OISD. He has not, my lord, relied on the OISD. I should show your lordship the Petroleum Act. But in the course of the argument, my lord, Mr. Chaudhary had relied on the OISD. Copy, sir. Well, I shall, my lord, make a copy available. I don't think your lordship will have that. My lord, may I just hand up?
Only one matter, indulgence, my lord. YST manual or the that was uh, available in the public domain. That was presented at the time of the argument.
That's very fine, my lord. Let me show your lordship. My lord, this is the Petroleum Act. My lord, this is the definition of OISD standard. And I'm sorry, my lord, this is a marked copy. Kindly forgive me. But my lord, kindly see, I shall, my lord, have a copy placed, my lord, with your lordship's, my lord, record. My lord, kindly see OISD and standard. Well, it refers to the oil and gas industry. The Petroleum Act, well, it provides for OISD standard only in respect of oil and gas industry. We are not in the oil and gas industry. We are, my lord, in the harbor. We are operating a mobile harbor crane for, my lord, doing, my lord, ultimately, my lord, the stevedore activities. That is consumers. Consumers. My lord, we are, my lord, consumers of HSD. We are not, my lord, in the oil and gas industry. My lord, he has not found anything, my lord, in the user's manual. He has not found anything in the operating procedure. He, my lord, now tries to rely on OISD, which, my lord, ultimately must be confined to the oil and gas industry under the provisions of the Petroleum Act, which do not have any application to, my lord, the operation of mobile harbor cranes, and particularly do not have any application, my lord, so far as these operations are not, my lord, carried out in the oil and gas industry.
So your point is that according to them, pump was not appropriate.
Yes.
This YSD is to be followed in case of oil and gas industries.
That's right.
So far as gas industries and oil industries are concerned, this is not one where the plaintiff is operating.
That's right.
So this YSD is not applicable to this industry.
That's right. First point. Second point, my lord, there is...
That means this pump may be used.
Yes.
There is no restriction in use of
That's
particular.
right. Now, my lord, the second point is, my lord, so far as the forensic report is concerned, there is no mention of OISD in the forensic report at all. My lord, this is something that is, my lord, ultimately developed as a part of, my lord, the answers in the course of cross-examination and arguments. Now, my lord, your lordship's question, inlet valve. My lord, where does the question of inlet valve come from? My lord, please have a look at, my lord, the, my lord, surveyors, the forensic experts report. That your lordship will find at Judges Brief, Volume 2, page 268.
It is marked.
Yes, my lord, it's marked. It's marked as exhibit koto by. Inlet valve to ashini এখন
Yes.
My lord, this is the report of Otonupal. He is, my lord, the forensic expert. I'm sorry, my lord. Yes.
Surveyor. He is surveyor.
Yes, my lord, surveyor. My lord, I'm sorry. I should show your lordship, my lord, page 581, which annexes. Kothay is screen factor report. But kindly give me a moment. I'm making a mistake.
Third volume দেখো তো third বা fourth volume.
Fourth volume.
দাও ওখানে মার্ক করা আছে.
Yes, my lord. I'm sorry. That's at page 679, volume 5. Volume 5, page 679.
Volume 5.
Your lordship will find forensic investigation report in respect of fire incident involving mobile harbor crane at Haldia Port belonging to IRC Natural Resources. Now, my lord, kindly forget, my lord, the initial parts of the report. May I show you, lordship, what is material? The photographs and everything is given. I don't think, my lord, I need to trouble your lordship with any of that. Please have a look at. Now, my lord, page 707. 706. Documentary evidence collected. Copy of Mobile Harbor Crane User Manual supplied by Terex Gottwald. Commissioning certificate, inspection report, report on incident of fire, daily information
So they said this copy was not given to them?
No. Well, this is given, but they again say, they say themselves that the copy is supplied. The copy made no mention of refueling procedure. There is a tank.
No, just a minute.
They had said, it's not supplied, but then they admit it's supplied. Whatever was there is supplied.
Yes. Documentary evidence collected.
Yes. Now, my lord, train users manual supplied. Now, my lord, pausing here for a moment, your lordship has seen that they have said that there is nothing that they found in the manual to say that the standard operating procedure for refueling the crane has been violated. Then, my lord, kindly see commissioning certificate, maintenance checklist, so on and so forth. I don't want to trouble your lordship. Now, my lord, next page 707. My lord, this is the details of step-by-step procedure for refueling that they identify. Please see second paragraph. Once the diesel tanker arrives, the team, 3 persons, will reach the spot and I will communicate to the operator through walkie-talkie about the readiness of refueling. Operator will put the crane in standby position and one of us will take the dip measurement of the tank and ascertain the quantity in the tank. Operator will stop the crane. Refueling is provided by using hose or pipe. Suction hose is connected from diesel tanker to pump motor and delivery hose is connected from pump motor to crane diesel engine main tank. Delivery hose is tied to crane railing in front of PLC room to stop any forward movement. Now, my lord, just pause here for a moment. So, my lord, what is said? That, my lord, a tanker comes. There's a delivery hose from the tanker to the pump and a delivery hose from the pump to the main, my lord, refueling of the main, my lord, engine of the crane. Now, my lord, the tank does what? It sucks out the pile from, my lord, the tanker and pushes the pile into the thing into the pump. Now, my lord, I am just, my lord, pausing for a moment, asking a very common sense question to myself. My lord, they say that, my lord, the inlet valve of the pump of the crane was closed. My lord, leaving the pump running. Now, my lord, when the valve is closed, when I try to, my lord, put extra fuel in a car, there's overflow. My lord, that overflow came through the pipe, came to the tank, it came to the pump ignited and burst. Now, my lord, today, my lord, kindly just for a moment imagine. For this to have happened, my lord, the tanker must have, my lord, remained there. So tanker, my lord, pumping oil through, my lord, the hose pipe into the pump, pumping it into the crane, my lord, ultimately
it could have flamed up.
The tanker would have, my lord, been burnt. My lord, the fire would have spread rapidly from the pump into the tanker. The tanker would have been in flames in no time. There would have been an explosion. Now, my lord, kindly see what, my lord, they say. This is the refueling procedure. Now, my lord, if your lordship will kindly...
Shah, let us pause today because there is a resolution of 3:30.
Oh, I see. I did not. Very well.
Is it not? Yes.
Then I can't continue.
Short date. Heard Mr. Shah in part. Adjourn to
$7th and 8th time in difficulty. Otherwise,
then 13th. 13th is okay. 13th.
May I request 14th, my lord?
14th, okay.
Grateful.
14th.
Witness action, item number 27.
I appear for the plaintiff, my lord. If my lord recollects, we have filed an application for recalling of the plaintiff's witness, my lord. My lord has rejected their application, my lord. We have preferred an appeal, my lord. So we want to try our luck in the appeal. So my lord, humbly praying for an adjournment. If my lord
in
can...
view of pendency of the appeal, witness action is adjourned to 10th June or 13th June.
Grateful to your lordship.
13. 28. Item number 28. Rita Ghosh.
Payment is made.
I am for the husband minus unfortunate.
You say that?
Absolutely.
You think 1 year's anniversary is over?
Just over.
Anyway.
Just over.
Just over. He keeps yes, just over. Yes. I gifted and we went. Now
Occasion, my lord, they're supposed to, my lord, file the draft, demand draft, as they proposed.
Only one thing, my lord. My lord will recall this is a matter of a dispute between the husband and the wife. Now, the husband has agreed to give the 60 lakhs as permanent alimony. In return, my lord, the wife will gift her 50% share in the property in dispute. She will also file.
Is it settled or
It's
not?
settled. And my lord,
Terms of settlement file, if you are
Right. And my lord, on the other hand, wife will withdraw all the pending criminal cases, matrimonial cases, and one more addition thing, both the parties will go before the family court and file a petition for mutual divorce and get separated. Now that process has initiated. Now this will take some amount of time to get that degree for mutual divorce. Other than that, my lord, other two criminal cases that can be withdrawn in
Can I fix it on June?
In June, my lord. In the meantime,
Well,
on the 60, just on the with regard to the 50 lakhs, remaining 50 lakh, we have prepared a draft, but we made it draft in the name of the wife. Now we will encash it and we will again make a draft in the name of the register of the High Court. We will deposit it. My lord will kindly direct the register to accept that money and
once you will prepare the draft, come here, I will give direction.
My lord, may I submit one thing? My lord, it was the terms of settlement is like that after receiving the remaining amount, my lord, but those
that's why it will be kept deposited with the register.
Yes.
And the register will.
But is it there? Terms of settlement?
Yes,
Yes,
it's
it is
part
there,
of the part of an application, and the register will invest it in a short-term fixed deposit. That we have already given them 10 lakhs to
Yes,
that I will again give them 50 lakhs. Only all these requirements are.
Page 12, my lord, the terms of settlement.
Terms of settlement had already been filed in his court. Was filed in his court earlier. Full stop. To show sincerity to carry out the terms of settlement.
10 lakhs given. 10 lakhs already given.
10 lakhs had already been given to the plaintiff by her husband, namely defendant number 1. Out of rupees 60 lakhs. The defendant number 1 shall deposit the rest 50 lakhs rupees with the registrar original site within a period of 15 days or 7 days.
But 10 days?
10 days.
10 days.
Or before the returnable date, which is the earlier.
Yes.
The suit will appear in the list for further order.
And the register will encash it and
on 15th May. On receiving the demand draft, the registrar will encash it and deposit it in a fixed deposit scheme in any nationalized bank for a short period.
But may I submit just one thing, my lord? But in the meantime, my lord, they are bound to pay the monthly rent to the wife, my lord, because she is in the another shelter, my lord.
The different number 1.
This 60 lakhs was on account of full and final settlement.
No,
We
your
already
lordship,
given
my lord,
more
according to the
pressure upon me. Don't pay the accommodation. You pay.
My lord, kindly come to paragraph
So much of pressure upon the husband.
paragraph 11, my lord, of the terms of settlement, page number 40.
He's going on borrowing money to buy peace. Now give me more money. You pay out of the
Defendants, my
money
lord,
you
have agreed that they
Shelter
shall
till
make
the
arrangements.
payment of all installment regarding 60 lakh is exhausted.
Yes.
So arrangement of shelter shall be made, no rent.
No.
Rent is to be paid out of own pocket.
Yes, she has to pay.
That is not specified. Arrangement may be made.
The already
The
arrangement
arrangement,
made.
my lord, she already took arrangement.
She will stay there. There is no provision for payment of rent.
And my lord, your lordship, on the last occasion when
Don't be too much bargaining. There should not be too much bargaining. You will lose everything then.
next date,
15th May.
May.
29.
29, I'm for the petitioner, my lord.
What is your matter?
My lord, the probate, my
Your
lord.
matter.
My lord, already.
Is it your matter?
I'm for the petitioner, my lord. Yes. My lord, this is the executor, my lord. The
Let her come.
witness, my lord, witness already died. The attestation witness.
Would you adduce evidence?
Evidence, my lord, only executor.
So why don't you calling her?
Yes. Sorry.
Do you know how to prove a will?
Yes, ma'am.
If attesting witness, all attesting witnesses are dead.
My lord, one attestant witness already dead. Or other witness others witness no found.
Well, probate will not be granted anyway.
But my lord, yes, my lord, I please your lordship. My lord, executor is visit. My lord, take the execution.
Yes, that evidence may be taken, but will is to be proved.
My lord, lordship is judgment is there, my lord.
আমি এই মামলায় সাক্ষ্য দিতে এসে যা কিছু বলবো সত্য বলবো, সত্য ছাড়া মিথ্যা বলবো না, কোনো কিছু গোপন করবো না। আমার নাম নন্দিনী শার্দুল, মিসেস নন্দিনী শার্দুল। শার্দুল, SARDUL অথবা দন্ত সহায়িকা দয়রে SARDUL অনিল কুমার শার্দুল, কুমার শার্দুল।
না, উজ্জ্বল কুমার সরকার।
আমার বয়স এখন 58। আমি শিক্ষকতা করি একটা স্কুলে। 80/1 কালিকাপুর রোড, 18/1। আর ম্যাক্সিমাম সময় আমি আরেকটা ঠিকানা একটা আচ্ছা আচ্ছা
কালিকাপুর রোড,
উজ্জ্বল
34 99
99
99 হ্যাঁ।
Yes, Shardul, you have seen the will.
Why have you come here to this court today?
আমি এখানে আমার প্রবিটটা গ্রান্ট করার জন্য এসেছি। প্রবিট
Probate of which?
আমার মা,
Look at me.
আমার মা একটা উইল করে গেছেন। এই উইলটা আমি হঠাৎ করে পাই, আমি জানতাম না।
My mother had executed a will. I suddenly discovered the will. This is the proceeding for probate. I have come here to depose on probate, on grant of probate of the will.
You have the knowledge the disease Maya Ghosh.
When your mother died?
My mother died 2nd July 2002.
Is there any death certificate here?
Yes, ma'am.
Where is the death certificate?
petition to the
Where is the original?
Second July 20200.
Where is the original death certificate?
My lord, I think the original death certificate already
It not be there.
No, filed, already filed to the one.
Where is it?
না না তুই বলছিস 2002 বলছি তো
আমি আসতে হবে। My lord, I will produce the original death certificate, my lord.
Original death certificate is not produced. Deferred. পরের দিন অরিজিনাল ডেথ সার্টিফিকেট নিয়ে আসবেন।
ওকে
My lord, make a short date, my lord. I will report it
Adjourn to
next Thursday, my lord.
8th May.
Okay.
I'm telling you, will is to be proved according to section 68.
Yes, I know.
Okay, thank you, sir. My lord.